rise.
Thank you.
District Court Magistrate Division is now in session. The Honorable Karen Evans presiding.
Thank you. Please be seated. All right, before we get started, I'm going to review one thing for the audience here today regarding disruptive behavior. Any activity or behavior which is considered disruptive by the court will result in removal from the courtroom. Any spectator who creates a visual or auditory disturbance of the court proceedings may be removed from the courtroom and or the building at any time at the discretion of me or court security. We'll now call the case. Madison County Magistrate Division of the District Court, CR 3320-302, State of Idaho versus Lori Noreen Vallow. Counsel for Ms. Vallow appears at the defense table. We have Ms. Elcox, Mr. Webb, and Mr. Means. Counsel for the state is Mr. Wood and Mr. Rammel. This is the date and time set for an initial appearance. The defendant is also present here in the courtroom. Counsel for defense, in the court pleadings, it designates Ms. Vallow, aka Ms. Daybell. How would your client like to be referred to by the court?
Mrs. Daybell, please, Your Honor.
Right. Ms. Daybell, do you read, speak, and understand the English language?
Yes.
Ms. Daybell, did you fill out a notification of rights form with your counsel prior to the hearing here today?
Yes.
Do you understand your legal rights here today?
Yes.
Do you have any questions about the form that you filled out or your rights?
No.
All right, we'll proceed forward then. Ms. Daybell, it's my understanding that you've hired these three attorneys that are with you here today, and that's your position that you'd like to retain your own private counsel. Is that correct?
Yes.
Did you get a copy of the criminal complaint as well as the arrest warrant that has been issued in this matter?
Yes.
Ms. Daybell, I can read the criminal complaint in its entirety, or we can summarize it going through each of the charges. Which would you prefer?
We will waive a formal reading, Your Honor.
We'll just go through the counts then, one by one, as well as the penalties. This criminal complaint was filed here in Madison County on February 18th, 2020. It is State of Idaho versus Lori Noreen Vallow, aka Lori Noreen Daybell. It charges the defendant with 5 different counts. The first count is desertion and non-support of children or spouse. That count is a felony under Idaho law, Idaho Code 18-401, Section 1. The punishment is up to a 4-year maximum imprisonment in the state penitentiary and or up to a $500 fine. It designates or alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or between the 23rd of September 2019 and the 18th day of February 2020 in the county of Madison, state of Idaho, did desert a child under the age of 18, to wit, JV, date of birth 5/25/12, who was dependent upon the defendant for care, education, or support with the intent to abandon JV. Ms. Daybell, do you understand what count 1 alleges, as well as the maximum penalties?
Yes.
Under count 2, it is that same charge, desertion and non-support of children or spouse. It's also a felony under Idaho Code 18-401, subsection 1. It is punishable by up to 14 years in the state penitentiary and or up to a $500 fine. It alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or between the 8th day of September 2019 and the 18th day of February 2020 in the county of Madison, state of Idaho, did desert a child under the age of 18, to wit, TR, with a date of birth of 9/24/2002, who was dependent on the defendant for care, education, or support with the intent to abandon TR. Ms. Daybell, do you understand what's been charged in count 2 as well as the maximum penalties?
Yes.
Ms. Daybell, count 3 is a misdemeanor under Idaho law. It's the charge of resisting and or obstructing an officer, a violation of Idaho Code 18-705. It's punishable by up to 1 year in the county jail and up to a $1,000 fine. It alleges that the defendant, Lori Noreen Vallow, a.k.a. Lori Noreen Daybell, on or about the 26th day of November 2019 in the county of Madison, state of Idaho, did willfully delay and or obstruct a public officer, to wit, Lieutenant Ron Ball of the Rexburg Police Department, in the discharge of his office by giving false information regarding the whereabouts of a child, JV, date of birth 5/25/2012, and thereby delaying the search for JV. Ms. Daybell, do you understand the charge in count 3 as well as the maximum penalties?
Yes, I understand the charge.
Count 4 is also a misdemeanor. It's a charge of solicitation. It carries with it up to 6 months in the county jail and a $500 fine. It's a violation of Idaho Code 18-2001. It alleges that the defendant, Lori Noreen Vallow, a.k.a. Lori Noreen Daybell, on or about the 26th day of November 2019 in the county of Madison, state of Idaho, with the purpose of promoting or facilitating the commission of a crime, encouraged and or requested Melanie Gibb to engage in conduct which would constitute the crime of resisting and or obstructing an officer, by requesting and or encouraging Melanie Gibb to give false information to law enforcement regarding the whereabouts of a child, JV, date of birth 5/25/2012. Ms. Daybell, do you understand the charge of count 4 as well as the maximum penalty?
Yes.
The last count is count 5. It's a misdemeanor under Idaho law. It's a charge of contempt, a violation of Idaho Code 18-1801, subsection 4. It's punishable by up to 6 months in the county jail and up to a $1,000 fine. It alleges that the defendant, Lori Noreen Vallow, a.k.a. Lori Noreen Daybell, on or about the 30th day of January 2020, in the county of Madison, state of Idaho, did willfully disobey a lawful court order in Madison County, case number CV 3320-45, by failing to physically produce minor children JV and TR to the Rexburg Police Department and or Idaho Department of Health and Welfare within 5 days of service of the order. Ms. Daybell, do you understand what's been alleged in count 5 as well as the maximum penalty?
I understand.
Ms. Daybell, do you understand that all of those charges and their maximum penalties could run consecutively, one after the other, or they could run concurrently, meaning at the same time? Do you understand that?
Yes.
In addition to the rights form that you've already filled out, pursuant to Idaho Criminal Rule 5, I'm also going to give you the following rights. Number 1, you are not required to make a statement, and that any statement made by you today can be used against you in court. Number 2, you're entitled to know the nature of the charges that have been brought against you, which we've already gone through. Number 3, you are entitled to bail. You have a right to bail. Number 4, you have the right to be represented by counsel. Number 5, you have a right to a preliminary hearing. That preliminary hearing must be set within 14 days if you're incarcerated. It can be set within 21 days if you're not incarcerated. That preliminary hearing is a probable cause hearing where the state will have the burden of showing probable cause that the 2 felonies have been committed in order for you to be bound over to the district court. You also have the right to communicate with counsel and immediate family, and that reasonable means will be provided for you to do so. Do you understand those legal rights, Ms. Daybell? All right, Ms. Daybell, now we'll schedule the preliminary hearing. I've met with counsel in chambers prior to coming out here, and there's a few dates that I believe did work. Mr. Wood, on behalf of the state, you designated that the state needs approximately 2 weeks to be ready, is that correct?
Yes, Your Honor.
And you also designated that the state needed 2 days for the preliminary hearing to take place, is that correct?
Yes.
Does the defense want to comment as far as how much time they need to be ready, as well as how much time the preliminary hearing will take?
Your Honor, I think 2 weeks is more than sufficient, and I agree with the proposed 2-day setting.
All right, the court has available March 18th and 19th. Does that work for counsel for the defense?
We'll make it work, Your Honor.
Does, Your Honor?
Your Honor, the state may have an issue getting one of our witnesses over here from Hawaii on the 18th. We had asked previously that it be set for the 19th and 20th and would continue that request.
Mr. Wood, if we made some arrangements so that if your witness could only be here by the 19th, that we allowed that witness to testify on the 19th, would that appease your concern?
Yes, Your Honor.
Does the defense have any objection to that, to moving things around a little bit so that that witness can testify on the 19th and not on the 18th?
No, Your Honor.
All right. We'll schedule then the preliminary hearing for March 18th and 19th here at the Madison County Courthouse. We'll schedule that right at 9 a.m.